Hello students. Today's topic, relevancy of judgment, decree, order, section 40 to 44. They may ask you a question as follows. Take the question. Explain the circumstances in which judgments of the courts become relevant. Okay? So when the question is asked like this, what you have to write? What will be your answer? There is a general rule. What the general rule says is, any judgment, any order, any determination of any court is not relevant. Is not relevant. It is only relevant to that case and it is not relevant to any other cases. Every day in our country there are hundreds of courts and there are hundreds of judgments, and you know, all the judgments will be relevant only to that particular case and it don't have any importance in respect of other upcoming cases. This is the general rule. I'd like to give an example, an illustration. Kindly keep it in mind, write in the exam for this general rule. Consider a newspaper. Just for our analysis, we will call BHASKAR is a newspaper. This newspaper published an article against Mr. A in the year 1991. BHASKAR published an article against Mr. A in the year 1991. Mr. A filed a case saying that the article is defamatory, it is destroying my name and fame. The matter came to the court. The trial was conducted for 2 years and the court gave the judgment. The judgment is, BHASKAR, you have printed, published a defamatory article on Mr. A. You have to give 20 lakhs of rupees as compensation for the defamation. See the judgment. So the newspaper, because of the judgment, he paid the compensation. Consider in the year 2001, same BHASKAR published an article on Mr. B. And now Mr. B filed the case in the court of law saying, this newspaper has destroyed my name and fame. Your article has destroyed my image. And the case, the trial has commenced. And in the trial, his lawyers, the lawyer of Mr. B says, Your Honor, you have to take the judgment of 1991. There, you know, the court has ordered the newspaper to pay 20 lakhs of rupees as compensation. We want the same judgment to be implemented here. And the court says, no, we are not going to implement the judgment of 1991, that judgment is only for that case. And in this case, the parties are different, the circumstances are different, the evidences are different. So, we have to decide as per the circumstance, evidences available in this case, and we are not going to accept the judgment of 1991. Saying old judgments are not having any importance in the upcoming cases. So, all judgment, decrees or orders are irrelevant. This is the judgment. And the question comes now, is it valid references of a judgment to the upcoming cases? So there, exception comes. In the exam, you simply write, in these circumstances, the old judgment plays an important role. It is very, very relevant. Okay? So, exception to the general rule. Okay? So, I'll explain one by one. Okay? Remember, just one para, that's all, and your answer will be full. Let us take the first exception. Resjudicata. It is defined in section 11 of the Civil Procedure Code. What is resjudicata? Means finality of litigations. When a civil case is finally adjudicated, agitated, and finally given the judgment, the same matter should not be recommenced once again between the same parties in any other court. Finally decided civil cases, there has to be a full stop. There has to be a finality. It should not be opened. It should not be recommenced. It should not be presented before any other courts in our country. Right? So, res judicata, finally decided civil cases, should not be entertained by any courts in our country. About 5 to 8 sentences, enough. Now we will go to the second exception, that is double jeopardy. Where you will find this word, double jeopardy? Constitutional law of our country. Article 20, subclause 4. That means it applies to criminal cases. Remember, both are same, but res judicata applies to civil cases, double jeopardy applies to criminal law cases. It says this much: no one shall be punished or acquitted twice for the same offense. That's all. In simple words, when a civil trial is conducted on a particular accused or a group of accused, and the matter has been finally decided, the matter has been finally decided, there is an end. And the judgment may be either acquittal Okay? The man is released with dignity, or the judgment may be conviction of the accused. When such a matter is there ends it, and after 6 months or after 4 months or after 1 year, the same case will be commencing in another court. Means law does not lie such a kind of cases. There shall be one conviction or one acquittal in one particular case. That should not be continued for a long time. There has to be a full stop. Okay? So this is one para. Now we will go to the third one. All of you know this. Probate. What is this word? Probate. Probate means it is the certificate of validity of a will. All of you know will. Will is a testamentary document executed by a person about his money, about his property, that has to be settled in the specified names of persons after his death. That is will. Okay? And you know who will write the will? Persons with a sound mind, sound body, they will write the will. Generally, your will be written once, or it may be altered or modified once again. It should not be repeatedly altered. That shows that the man is having unsoundness of mind. Okay? So, consider a case. Illustration. Better you take an illustration. One Mr. A is having a will document with him, and he approaches the district civil court and files the petition. One Mr. A, having a will in his name, in his favor, he approaches the district civil court and pay the fees and request the court, Your Honor, declare the validity of this will. When such a petition is presented, the court will give notice to all the persons, all the concerned persons, to submit their objections and to come before the court of law and to make the claims and counterclaims. So all the concerned persons will come to the court of law if they have any claim. If anyone say, no, this is not a will, this is not a true will, this is a bogus will, they have to come to the court of law. They have to tell the court of law how it is true or how it is false. Consider Mr. A has claimed, and the court has invited the objections, and the people have come with the objections, and the trial has been conducted. Lawyers have presented their evidences on both the sides. And finally, consider that Mr. A is found to be the original beneficiary under the will. It is a lawful will, and the court, after proper conduct of the trial, it has given a certificate of probate. Okay? Probate has been given. Now comes the problem. Now, according to the probate, the whole world knows. It is called judgment in rem. The whole world knows Mr. A is the holder of that property. So, for this property, so many money has to come. So many money, for example, rents from different persons, has to come to Mr. A now because he is the owner, he is the beneficiary under the will. Mr. A, consider there are so many shops which is paying rent to the testator earlier. Now A has to receive the rent. Now all the tenants came, paid the money, rent, and received the receipt. Subsequently, after 1 or 2 months, another person comes. He challenges the probate given by the court. And we will call him as Mr. B. And that B, he has produced some other evidences. And now the court, after 1 year, 2 years, the court has given another validity, saying the first probate is not hold good now. Now Mr. B is the owner of this property. Now our question is this much. Those persons who has paid the rent to Mr. A, can the new person having a new certificate, can he compel them to pay the rent once again or not? According to this chapter, it says the probate is a valid certificate by the court about the will, genuineness of the will. On the basis of this certificate, the tenants have given the rent to Mr. A. So, it is a valid transaction. Now, the new person, Mr. B, do not have the right to demand once again the payment by those persons towards the property. Okay? So, probate is a valid judgment. It is a protection available to all the persons who have paid the money on the basis of the probate. Okay, this is one para. We'll go to another, matrimonial judgments. Let us take an illustration here. Matrimony means marriages, divorce. Okay. Consider a husband and wife. Husband is also earning, wife is also earning. Now husband has made lot of loan and the wife was started clearing the loan from her salary also. So wife is cooperating with the husband, he is loving the husband, she is started fulfilling the loans of her husband. But time will not be the same always. Time will change. Suddenly there was a fight between husband and wife. And the case came before the court. And both of them wanted the divorce. Both of them wanted the divorce. The court gave them the divorce, judgment of divorce. Now husband is different, wife is different. This is a judgment in realm. The whole world now knows that they are no more husband and wife. Afterwards, one creditor of the husband wants to file the case against the wife, saying, you have to give me the loan that was made by your husband. See, after the divorce, some man, creditor of the husband, files the case against the divorced wife. And there she comes with the copy of the judgment, saying, here is a piece of evidence which shows that I don't have any relationship with my ex-husband. I am not responsible for whatever loan that my ex-husband has made. So, the law says, yes, the copy of the judgment of divorce is relevant. And it is a shield to the lady that no one can compel her to take the liability of her ex-husband's loans. Okay? Yes. Now we will go to another jurisdiction, another judgment, that is judgment of insolvency. You know, some of us make loan, always loan. When they make the loan, when they keep on making the loan, someday they may become a failure. Consider they have property, they have some property, but the loan is too much and the property cannot fulfill the loans. When they cannot give back the money to all the creditors, they don't have any other route. They have to come to the court of law with a petition, with a request that kindly declare me as a pauper, P-A-U-P-E-R, pauper, or as an insolvent. Declare me as a pauper or as an insolvent. There are people in our society who have taken the judgment of insolvency. When any such petitions have been filed before the court of law, then the court will not keep quiet. It will call upon all the concerned person, opposite persons, creditors who have given loan to this applicant, to the petitioner. They will collect information, how much money they have given, what is the existence of the property of this applicant, and the court will see how much loan can be cleared out of it. Then, with wisdom, the court will give the minimum properties to the care of this person so that he can lead a small, simple life. And afterwards, the court, it will give declaration that this man from this moment is insolvent. He is a pauper. That judgment is very, very relevant. From the moment of the judgment, no other person can claim any liability, any loan, any money, any property from the insolvent person. It is a shield, it is a protection. But the pain here is, if any man secures an insolvent judgment, he will not be considered as a legal personality under Indian Contract Act 1. He loses the capacity to contract. Okay? So, insolvency judgment. And the last one, it is not in our life, admiralty judgment or admiralty cases. It comes under the international law. It comes about the jurisdiction of the Supreme Court of India in deciding whether an aeroplane, whether a ship belongs to the enemy country or to the friendly country. So Supreme Court is having the capacity to judgment. So do not write much on this, only 2 sentences. This is the jurisdiction of the Supreme Court in deciding the character of the aeroplane or the ship, whether it belongs to the enemy country or the friendly country. That's all. It's not in our day-to-day life. But last point, judgment of fraud, judgment of collusive character. Here I would like to give one illustration. There are cases without jurisdiction, without powers, they conduct the cases. Both the lawyers will be involved in that. The judge will be involved in that. There will be corruption. And the judge will give a judgment without the jurisdiction, without the power. But on a future date, when the judgment is read by some wise men, they are going to challenge the judgment as judgment of corruption, judgment of fraud, judgment of collusiveness. Okay? So, to prove that, for example, one small illustration, you take an ordinary magistrate court, very lowest magistrate court in entire India. He may give a maximum of 1 year of imprisonment or some small amount of penalty, just for our analysis. And now the question is, two lawyers and the judge combined together, there was transaction, and both the lawyers, they wanted to see that the victim has to suffer. So the magistrate wrote punishment for 5 years. Thinking that victim don't have anyone, no protection, nothing, he can be victimized. But who knows, after 2 months or 3 months, some social organization, some person will raise the matter in the superior court and bring it to the copy of the judgment showing this court do not have the jurisdiction. How can they decide it? So this is the proof of corruption. This is the proof of fraud, collusiveness on the part of the court and also the advocates. Okay, so until this, you write about 4 pages of answer, okay, with simple illustration, right? So this is enough about relevancy of judgment, decrees, order, section 40 to 44. Okay, you need not write each and every section. Write this much. Write this much. Section 40 to 44 easy to remember. You may not remember 41, 42, 43, 44. No, you may not remember. And all these points I have explained here. Okay, so enough for today. Thank you.